Welcome to the Republican Professor. I'm your host and my own host, Dr. Lucas J. Mather. It's a wonderful October night in SoCal, in the backyard by the pool today. There's the waterfall, got the pool light on, having a cigar. It's a Connecticut Toasty Jones. Not a paid sponsor. It's not my backyard. It's my mentor, Dr. Doug Guyvet. Been house sitting for him for 22 years now. Take wonderful care of their backyard. They've had this pool for the whole time. Done a wonderful job. And by the way, guest on this podcast, Dr. Guyvet, Ph.D. from USC in philosophy under Dallas Willard, and is a professional epistemologist. Taught my epistemology courses, some of them, in graduate school. Also philosophy of religion, co-taught with Professor Richard Swinburne from Oxford, who looks like a hobbit and acts like a hobbit, talks like a hobbit. He would lecture and his feet would grab the carpet almost like little hands. I don't know why he didn't wear shoes, but I guess hobbits don't really wear shoes. Anyway, we appreciate the work that the California Rifle and Pistol Association has done, along with Second Amendment Foundation and others, to bring these ridiculous attempts at regulating firearms to heel. And one such that we're covering tonight is the one from July of 2025, a divided panel, but nevertheless, Republicans on the Ninth Circuit struck down, they affirmed a district court grant of permanent injunction that held that California's ammunition background check regime, which required firearms owners to complete background checks before each ammunition purchase, facially violates the Second Amendment. Facially violates. This was not an as-applied challenge, which is, I think, easier. This is a facial challenge. Boom. Bam. July 24th, 2025. It's still being litigated. The En Banc will have something to say, the Democrats. But the Republicans on the three-judge panel had the right answer, and because we are an educative podcast, when we see the right answer, we share the right answer, because voters need to know how to articulate this stuff, how to think about it, who gets credit for what. And I'm telling you, the Republicans get credit. Unfortunately, there is somebody in dissent, and it's also a Republican, a Bush appointee, Judge Beebe. A Mormon guy, too. But by the way, what the heck? You're a Mormon. You should know better. Give me a break, Judge Beebe. Nevertheless, two women, Sandra Akuta and Bridget Bade, had the right answer. Bridget Bade, Trump appointee, I believe. I think Akuta was Bush. But, dude, let's get into it. Affirming the district court's grant. Oh, that's too bright for the... let me pull it up on Firefox. You can get to it by searching Rody versus Bonta. And this is the Ninth Circuit government website. Boom. For publication. You like to see the for publication across the top. You know why? Because that means it's got some teeth. That's what that means. I'm scrolling to page 2. I'll put the link in the description. But this is appeal from the United States District Court for Southern District of California, Roger T. Benitez, District Judge presiding. Oh man, he is great. Argued and submitted December 4th, 2024 from Pasadena. Filed July 24th, 2025 before BB Boo, Sandra Ikuda, and Bridget Bade. The women coming out swinging for the Second Amendment and hitting a home run. Praise God. Speaking of which, I just remembered I was supposed to start with I'm being a very bad chaplain here. I'm supposed to start with a psalm and a reading from Streams in the Desert. I think it's because I'm house sitting that I'm out of my element here, and I'm not doing my normal. I do my Bible reading. I did my Psalms study out there earlier, but I'm not getting it on the podcast like I normally do. I apologize. Affirming the district court's grant of permanent injunction. Let's just pray instead of doing the psalm. I'm going to pray. I'm going to lead us in a chaplain prayer. Okay. Creator God, Lord, thank you for this decision. Thank you for these women that stood up for the right answer, for self-defense. Lord, we know that in your world, a fallen world, not how you created it, but that's the way it is now, a world that you're redeeming and replenishing for yourself according to your own purposes through Jesus Christ our Lord. We know that self-defense is necessary, and we wish it wasn't so. And sometimes self-defense is the best way to love our neighbors, as we're commanded to do. How can we stand by as someone is attacked and beaten? The Good Samaritan story, the Good Samaritan shows up after. But what about if he came before or during? Lord, we just want to be good stewards of what you've given us. And you have given us this freedom. We ask that you would help us protect what's valuable. Be good role models and examples to the younger people. To love our neighbors well. To fight evil in a just way. Bring about greater flourishing for your creation. And we ask this in Jesus' name, amen. The reason I do that is because I think it's good to acknowledge that, well, if God exists, and some of you don't agree with that, but if God does exist, and I think he does, I think it's good to acknowledge and thank him for what he's given us. And to ask him for help and wisdom in preserving what's valuable and creating more value in the world. And I think the Second Amendment, rightly understood, helps us do that. So let's continue. It's 25 October 2025, years after Jesus. The panel applied the two-step framework set forth in New York Rifle and Pistol Association versus Bruin. Okay, hold on. I'm in the summary. Let me go. Here's the council. Oh, there's Aaron Murphy. We know that name. Paul Clement. We know that name. And we got Chuck Michelle, two-time guest on the podcast here, president of the California Rifle and Pistol Association. Great. This is great. Okay. Scrolling down. Lots of attorneys. What a waste of money. Look at what you've done, Democrats. How much money you're wasting. Here's Ikuda, circuit judge, writing the opinion of the court. This appeal raises the question whether California's first of its kind ammunition background check regime, which requires firearm owners to complete background checks before each ammunition purchase, violates the Second Amendment. We hold that California's ammunition background check regime is unconstitutional, and we affirm the district court's grant of permanent injunction. That's the right answer. Okay? You need to know as a voter and as a thinker what the right answer is. We share the right answer. Even if the En Banc panel, controlled by Democrats, and when you add people like Ph.D, who's a Republican, technically, by the way, like I said, Mormon, he should know better. Come on. Griffith was a Mormon, and look at what he did in Wren versus D.C. in 2017. He got the right answer. He was a missionary in Japan. That's how he grew up. I believe he grew up in Japan as a missionary. I mean, I might be wrong about that. Maybe he just did his mission. Anyway, he went to a place that was disarmed. He didn't fall in love with it. He didn't go native, as we say. Well, you have Ph.D screwing it up for us. But he didn't screw it up at this level. Ikuda was holding it down the fort. This is a Ninth Circuit panel controlled by Republicans, and they get the right answer. You need to know that as a voter. You need to know that. California, in 2016, California voters approved Proposition 63, which created a background check regime for ammunition sales. This regime went into effect July 1, 2019. The effect of that going into effect, I'm telling you this, I was watching carefully, was fewer places offered ammunition. Walmart, for example, was a staple ammunition vendor right up until that time period, and then they stopped. Why? Because it was too costly for them to implement this. They tried it, but it was too costly. So one of the best places you could get ammunition at a very good price was Walmart. And this effectively ended that in California. So poor people who need ammunition, this affected them. California requires residents to purchase ammunition through licensed ammunition vendors and face-to-face transactions. Other states, they can get it through the mail. The sale of ammunition must be approved by the California Department of Justice, referred to here as the department, at the time of purchase or transfer, prior to the purchaser or transferee taking possession of the ammunition. The statutes and regulations provide a detailed description of the 4 ways that a person can obtain authorization to purchase ammunition. Why is this important that Ikuda is going through this? So, because prior to this, it's like you just buy ammunition. It's like buying anything else you need at Walmart. You need some underwear. You need some lipstick. Do you need some shaving cream? You need some Zippo lighter fluid. What do you need? You need some sterno. Ammunition. You need some fish hooks. And that's how it is. That's how it's always been. Now you're saying, now the Democrats want you to ask permission to the government before you buy it. And the government is supposed to go, and by the way, you pay for the privilege of asking permission. Not only do they insult you by asking permission, but they make you pay the government to ask you permission, ask permission to buy ammunition. And I'm talking about like buying a box of 22s. The statutes and regulations provide a detailed description of the 4 ways that a person can obtain authorization to purchase ammunition. First, a basic ammunition eligibility check authorizes a single transaction for any quantity of ammunition. By statute, the department shall develop a procedure in which a person who is not prohibited from purchasing or possessing ammunition may be approved for a single ammunition transaction or purchase. See that they go by each transaction. You have to ask permission. It's not like driving a car where you get a license to drive a car. You don't have to ask each time you drive it. And then, by the way, pay for that. It would be like if you wanted to drive your car. Can cars kill people? I've heard of that happening. I've heard it happening actually a lot more than firearms, if truth be told. But you can have a dangerous, possibly dangerous thing happening driving a car. And it would be like you have to ask permission for each time you drive the car. You want to go to the store, you got to ask permission. You got to have approval for that particular thing. You want to drive back from the store, you got to have approval for that. That's how invasive this is. The department has imposed a fee of $19. That's for each one. To run such a basic check, a vendor swipes the prospective purchaser's driver's license or other government ID. So you have to have a government ID. That's interesting. You need to have ID. Well, if the Democrats are to be believed as far as voting goes and voter ID, they don't think that, quote, people of color, unquote, are smart enough to get government ID. So this sounds like a disarmament scheme for people of color, quote unquote, at least the way they're thinking of it. The system then automatically checks the purchaser's identifying information in 4 state databases. Wow. The Automated Criminal History Record System, Mental Health Firearms Prohibition System, California Restraining and Protective Order System, and Wanted Person System. If the person's name is not listed in any of the 4 databases, the basic check is completed automatically. If the person's name is listed in any of the 4 databases, a department analyst manually reviews that database to confirm that the prospective purchaser is correctly listed in the database. If the automatic or manual check shows the person is eligible to purchase ammunition, the person is approved for a one-time purchase or transfer. And by the way, this is transferring too, like you want to give it to somebody as a gift. Otherwise, the person is not eligible to purchase ammunition. Basic checks take an average of 5 to 6 days to process. Geez. Approval for basic check expires 30 days after it is issued. Well, how come that same basic check doesn't apply to subsequent purchases then? Second type of background check is known as a standard ammunition eligibility check and costs $1. A person whose information matches an entry in the Automated Firearm System, AFS, and is not listed in the Prohibited Armed Person file is authorized to purchase ammunition pursuant to the standard check. Okay. The AFS is a repository of firearm records maintained by the department, and which includes dealer record of sale of firearms. A person is charged a DROS fee. That's a gross fee of $31.19 for each firearm transaction. Under the department's policy, standard ammunition eligibility check approval is valid for 18 hours. If a person is rejected from a standard ammunition eligibility check due to the lack of a current matching AFS entry, the person may be able to obtain ammunition by paying the $19 fee for a basic ammunition eligibility check. In other words, if you have a firearm registered with the California DOJ, you can pay $1 if they say you have a firearm registered. Notice you're going by what the records that somebody else keeps, So, okay. Third, a person may obtain authorization to purchase ammunition by having a current certificate of eligibility issued by the department. To obtain a certificate of eligibility, person must pay the $22 application fee, undergo an application process that involves fingerprinting and a criminal background check. A certificate of eligibility must be renewed annually. Each renewal costs $22. Certificate of eligibility holders must pay a $1 verification fee at the time of each ammunition purchase. Under the department's policy, following each verification, a certificate of eligibility holder is approved to buy ammunition for 18 hours. How are we doing on this? Hanging in there? Finally, a person who is approved by the department to buy... By the way, okay, just let's get through this a little bit, but I want to just say, remember, they're going to say this is unconstitutional. It facially violates the Second Amendment. So pay attention to this, because this is very helpful to know. This violates the Second Amendment. I think it's very helpful to know. And I know this is not the final answer as far as the Ninth Circuit goes. It's still being litigated. They appealed. But this is the right answer. So you have to study the right answer, because this is what you want to see at the Supreme Court. You want to see this resolved, or a case very similar to it that gives instructions for how to resolve these, that somehow weakens the Democrats' stranglehold on these things. I like to see the Republic. You need to know this is Republicans that are holding the line here. Why do you need to know that? Because the hard work in elections matters. It really does matter. Republicans don't control the Ninth Circuit yet. You have to understand, as of May of this past year, there was so much going on with the Senate and the Congress, they didn't have a chance to get to any of the judicial nominees. There's too much in terms of the executive branch getting those guys nominated and confirmed. And by the way, the federal government is way too big. There's way too many of these confirmations that need to take place. That's part of the problem. So we need to keep the ball rolling here. As far as judicial nominees, I know this issue is important to a lot of you. It's important to me, that's for sure. A person who is approved by the department to buy a firearm. I see, this is another thing I don't like, is you have to ask permission to buy a firearm. That's really annoying to me. really annoying. I'm talking about in California. A person who is approved by the department to buy a firearm may purchase ammunition in the same transaction as the firearm purchase if the ammunition vendor is a licensed firearm dealer and certain other requirements are met. The buyer must pay the $31.19 fee for the firearms eligibility check. California subjects firearm transactions to a 10-day waiting period. And ammunition purchased as a part of the firearms transaction is subject to the 10-day waiting period as well, unless the buyer undergoes another type of background check and pays a separate fee. California residents, by the way, we did a whole series on waiting periods. I think there's 7 episodes up now. If you go to YouTube, you can see these playlists. Second Amendment waiting periods. Second Amendment assault weapons. Second Amendment women in firearms. Second Amendment local activism. Second Amendment concealed carry. Second Amendment magazine capacity. You'll see these different playlists that we have on the Republican Professor. We're building this out to be a resource to you. California residents cannot bypass face-to-face transactions with licensed vendors by purchasing ammunition in another state and bringing it into California. Therefore, see, this is the thing. You can buy ammunition online in Arizona, in Nevada, in Utah, in Montana, in Idaho. You can go to Walmart and buy it in those states. You can go to, just a normal store and buy it. Not in California. They say, nope, and you can't bring it in from another state, is what they're saying. Therefore, while California residents may buy ammunition remotely, such as over the internet, they may not. I'm talking about buy on the internet and have it sent to your home, by the way, in other states. While California residents may buy ammunition remotely, such as over the internet, they may not access the ammunition without a face-to-face transaction in California. If residents purchase ammunition outside of California, they must have the ammunition delivered to a licensed ammunition vendor for delivery pursuant to blah, blah, blah. I'm looking at footnote 6 right now. Do you know what one of the exceptions are? Uses of as a prop in an entertainment. So the film people get an exception. What a bunch of crap. They're buddies in the film industry. Wow. Okay. If neither party, I'm on page 15 now. If neither party to an ammunition sale is licensed vendor, the seller must deliver the ammunition to a licensed vendor for processing. When ammunition has been delivered to a California licensed vendor on behalf of a California purchaser. Well, I mean, look how long it takes just to explain the damn regulations. And we're not even done. Some people just don't get it, and they will never get it. But those who do get it you're still here and you're still with me on this. Let's keep going because there's good news ahead. There's reason for hope. You have not existed in a vacuum. Your persuasive efforts have paid off electorally. Good job. Keep going. Support people like Chuck Michel at the California Rifle and Pistol Association. Support Alan Gottlieb, Second Amendment Foundation. Do what is needed to get the right people elected and people educated. When ammunition has been delivered to a California licensed vendor on behalf of a California purchaser, the vendor must take several steps before delivering the ammunition to the purchaser. First, the vendor who receives the ammunition must verify with the department the buyer is authorized to purchase ammunition. By the way, who's paying for all this? Who's paying for that time? You see that California is commandeering private businesses. If the department's records do not list the buyer as an authorized ammunition purchaser, the vendor must deny the sale or transfer of the ammunition. Oh, by the way, they have to store this ammunition. Talking about gun stores, right? You're talking about gun stores. Firearm vendors, gun stores. They have to store all this ammunition and do all this work so people can buy ammunition. It sucks so bad. It's a taking of private property. If the department's records do not list the buyer as an authorized ammunition purchaser, the vendor must deny the sale or transfer. In other words, a vendor page 16, may not deliver ammunition to a buyer unless the buyer is authorized to purchase ammunition. If the buyer is so authorized, the licensed vendor can charge the buyer a processing fee. Okay, so now the cost of the ammunition just went up again. The department has the authority to set the amount of these fees. Oh, well, thank you very much for that. Another taking right there. Instead of letting the market decide the fees, the government decides the fees. If the purchaser is present for immediate delivery, the process fee cannot exceed $5. You're telling them they have to pay minimum wage. They have to pay a minimum wage, right? And yet, this extra work, they can't charge more than $5 for it. Okay. You see the contradictions here? Basically, what they're doing here is they're running gun stores out of business. That's what they're doing. And this is only part of it. I'm not even telling you the whole story. There's a First Amendment challenge up. There's been 2 First Amendment challenges, one that we won and one that's being litigated right now. I can't get off on that, but it's draconian and disgusting what is happening to firearm vendors in California. If the buyer is so authorized, the licensed vendor can charge a fee, but it can't be over $5. But if the purchaser is not, page 17, present for immediate delivery, the vendor can charge an additional fee for storage of the ammunition. The purchaser must agree to the storage fee before the vendor receives the ammunition, but the department places no limit on the amount of money that vendors can charge for storage. Licensed California vendors may also decline to process third-party ammunition transactions. Now, look, the reason that people shop online for ammunition is because of price. usually it's you get better deals. So all this takes away all that reason and rationale for that entire industry, and makes the cost of ammunition rise drastically in California because there's no competition. So it's hurting the consumers as well as the vendors, which is the point of this harassment. The department must approve the sale or transfer of ammunition at the time of purchase or transfer prior to the purchaser or transferee taking possession. Contrary to the dissent, obtaining such approval is not limited to a $1 fee and is not free from delay. A standard ammunition eligibility check costs $1, but only if the person previously paid a gross fee of $31.19 per firearm. Similarly, by the way, that fee has gone up now, I think. Similarly, a certificate of eligibility holder must pay a $1 verification fee at the time of ammunition purchase, but the holder must pay $22 on an annual basis to be a certificate holder. And by the way, they harass you if you want one of those. Other than that, other than the 10-day waiting period for purchasing ammunition as a part of firearms transaction, there is no language in the applicable rules regarding the allowable delay time in approving or denying a background check. The statute requires that approval occur before a person can take possession of ammunition, but it does not require that approval begin within a certain time period. Because this appeal involves a facial challenge, which is the hardest challenge to meet, a facial challenge to the California ammunition background check regime, United States versus Rahimi, Supreme Court case in 2024, directs us to consider whether the law on its face fits with the plain text of the Second Amendment and this nation's historical tradition. B. We're in letter B. We now turn to the facts of this case, and I gotta take a break. I gotta take a break to get some water and to get a little bit of refreshment. We'll be back in a second.
Recording in progress.
All right, I'm back. You guys want to see what I'm looking at? Got the pool light on, and yeah, this is what I'm looking at. Got the waterfall going. That's what you hear in the background. There is a slight breeze. It's a little bit cold. A little bit. That's not like cold. I grew up in Colorado, so I'm not complaining by any means. But it's a nice night for a cigar. It's a nice autumn night. It's a nice Charlie Brown, Great Pumpkin night. We just watched that 1966 special. We have the DVD. It's just wonderful. It's just wonderful. It's brilliant. Yeah, I don't like doing these episodes on the Second Amendment, to be honest with you, because it's embarrassing, man. It's embarrassing what we have to go through in California. I mean, it's so ridiculous. But we do them because we know that we have listeners outside of California, including outside of the United States. The people outside of the United States are not going to be shocked by anything. They might be thinking that this is way too liberal in the classic sense here in California. But everybody here in California, when you compare them to other states, you need to know what we're going through here. You need to know what people in New York go through, and D.C., and what people in Chicago have had to go through. We're going through what Democrats want to do federally. You understand that? Do you understand that? That's why I'm doing this. Because you have to you have to get woken up here. You know? There's more work to do. I know it sucks. It sucks that we have to do this. But this is the work that needs to be done. So let's continue. Not to bring up health food, but let us continue. Go back to my California's themed background here. We're going to get through this, guys. Also, by the way, guys, you have to understand that the judges that are getting the right answer on this, that are Republicans, you need to know that too. You need to know which side is which here. So we continue. The facts of this case. In 2018, the lead plaintiff, Kim Rhode, who has won Olympic medals for trap and skeet shooting, filed this pre-enforcement action along with 6 other California residents, 3 out-of-state ammunition vendors, and the California Rifle and Pistol Association Incorporated. So the plaintiffs are called Rhode. Challenged California's ammunition background check regime on several grounds, 3 of which were relevant to this appeal. Rhode argues that California's ammunition background check regime infringes upon California residents' Second Amendment right to keep and bear arms, violates the Dormant Commerce Clause by barring unlicensed out-of-state ammunition vendors from selling ammunition directly to Californians, and is expressly preempted by 18 U.S.C. Section 926A. The district court issued a preliminary injunction barring California from enforcing the ammunition sales background check provisions found in California Penal Code, blah, 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 and the ammunition anti-importation provisions found in blah, 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 after the Supreme Court issued its decision in New York Rifle and Pistol Association versus Bruin. By the way, those 2 district court cases were 2020. After the Supreme Court issued its decision in New York Rifle and Pistol Association versus Bruin, we vacated the preliminary injunction. Not cool. Remanded to the district court for further proceeding consistent with Bruin. Rhode versus Bonta, 2022. Okay, on remand, the district court consolidated the hearing on a motion for preliminary injunction with a I think I want to read footnote 13. But I'm going to finish this sentence. On remand, the district court consolidated the hearing on the motion for preliminary injunction with a trial on the merits. Yeah. Page 20. Pursuant to Rule 65A2 of the Federal Rules of Civil Procedure, and each party submitted evidence. Okay, hold on there. I'm going to go back to prior page, page 19, footnote 13. 18 U.S. Code Section 926A provides the following. Notwithstanding any other provision of any law or any rule or regulation of a state or any political subdivision thereof, that's a county or a city, any person who is not otherwise prohibited from this chapter from transporting, shipping, or receiving a firearm shall be entitled to transfer a firearm for any lawful purpose from any place where he may lawfully possess and carry such firearm to any other place where he may lawfully possess and carry such firearm if, during such transportation, the firearm is unloaded and neither the firearm or any ammunition being transported is readily accessible or is directly accessible from the passenger compartment of such transporting vehicle, provided that in the case of vehicle without compartment separate from the driver's compartment, the firearm or ammunition shall be contained in a locked container other than the glove compartment or console. Did you catch all that? What that means is if you have a truck and it's just a truck bed, so you can't lock the truck bed, so you don't have a trunk, you can have it in the cab of the truck, provided it's unloaded and the firearm is separate but equal to the ammunition. At least one of them is in a locked container so that they're not together. Yeah. That's what that said. If you have a trunk, then the trunk is a locked container for these purposes. Also, like, station wagon, a station wagon doesn't really have a trunk that's lockable in the same way. Or like a Prius, one of those fancy schmancy Priuses. Do they have a... I've never had one, so I don't know. Do they have a lockable trunk? I don't know. No, I don't know. Anyway, following the hearing on page 20, the district court permanently enjoined California from enforcing the ammunition sales and background check provisions found in those sections and from enforcing ammunition anti-importation provisions found in those sections. District Court also enjoined California from criminally enforcing blah, 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 blah. By the way, these are criminal laws. Maybe this is something I should talk about. California is adding criminal law, which means they're taking innocent conduct and criminalizing it. It's the worst thing a government can do, is criminalize innocent conduct. It's what all tyrannies do. It's not loving your neighbor. For you Christians out there, this is not loving your neighbor. Creating criminals out of innocent people is not loving your neighbor. And violates the highest law in Christianity, which is to love your neighbor and your God as yourself. Love God with all your mind, heart, soul, strength. Love your neighbor as yourself. Would you, Gavin Newsom, would you create criminal conduct from your own innocent conduct? No. You wouldn't do that. So it's wrong to do it to other people. It's wrong. And these Republicans on the California Ninth Circuit are saying this is wrong. It's legally wrong. It violates the Second Amendment. So the district court enjoined California from criminally enforcing these sections. It concluded that California's ammunition background check regime violated the Second Amendment and that the anti-importation provisions violated the Dormant Commerce Clause. It also concluded that section blah 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 was preempted by the federal statute to the extent that it criminalized, listen to the language here, it criminalized a California resident's transportation of ammunition into California from other states. It's like if you bought underwear in Arizona, but California said no, you got to go to a licensed vendor in California. You need to ask permission to do that. You'd say, take off, hoser. Hey, take off, hoser. Remember Strange Brew? Is it just me? California appealed. Shocker. It moved to stay the district court's permanent injunction and judgment. A motions panel of this court granted the motion. Fart. That's a shocker, too. We have jurisdiction to review the final judgment under 28 U.S.C. Section 1291. We review for abuse of discretion in the district court's decision to grant or deny permanent injunction. Okay, so the trial judge got it right. Bush appointee, Republican, did it right. Benitez, awesome. Comes from a Cuban family, knows what it's like to live under tyranny. Bam. These other Republicans on the appeals court said the Cuban guy at the lower court was right. We review de novo the legal conclusions underlying the district court's decision, where, as here, the district court has consolidated proceedings. We review its factual findings for clear error. Because Rody brings a facial challenge, which is the hardest one to bring, we consider only the text of the challenged rules. Awesome. Roman numeral 2. We're cruising through this. The Second Amendment provides that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. U.S. Constitution, Amendment 2. New York State Rifle and Pistol Association versus Bruin guides our analysis. Bruin provides a two-part framework for assessing Second Amendment challenges. When the Second Amendment's plain text covers an individual's conduct, the conclusion presumptively protects that conduct. The government must then show that the challenged rule is consistent with this nation's historical tradition of firearm regulation. Let me read that again. The government must then show. You see, this is the genius of Bruin. By the way, Republicans on the Supreme Court. Why do you keep saying that? Well, it's the Republican professor you're listening to. Why do you think I'm saying it? Hello? Hello? McFly. I love 80s references and I will never apologize for them. I really don't want to have to do this. But Bruin said the burden of proof is on the government. What a concept. What a concept. The government wants to regulate the hell out of you and get more money from you in order to violate your rights and control you. The Republicans said, no, that's not how we roll in America. And you need to know that as a voter. Where am I wrong? Where am I wrong? Show me where I'm wrong. The Supreme Court, and this is an A, Roman numeral 2, the Supreme Court has interpreted the text of the Second Amendment to refer to bearable arms. Okay, so we're not talking about nuclear weapons here, okay? We're not talking about tanks. We're not talking about F-18s. Bearable arms are weapons of offense or anything that a man wears for his defense or takes into his hands that is carried for the purpose of offensive or defensive action. The term arms encompasses commonplace weapons as well as military weapons. Damn. Oh no, you didn't. Oh no, you didn't say that. No, you didn't. Oh no, you didn't. The Second Amendment reaches instruments on page 22 at the top that constitute bearable arms, regardless whether those instruments existed at the founding. That's Rahimi, 602 U.S. at 691, quoting Heller, 554 U.S. at 582. The Supreme Court has indicated that the Second Amendment protects operable arms. Because arms are inoperable without ammunition, the right to keep and bear arms necessarily encompasses the right to have ammunition. Stick that on a coffee mug, put that on a t-shirt, put that on a hat. That's February in Natural Right magazine centerfold. This is why Satan doesn't like this podcast. And why YouTube doesn't either. A firearm is not available for the purpose of offensive or defensive action if it is unloaded. In other words, the right to keep and bear arms incorporates the right to operate them, which requires ammunition. See Jackson versus City versus see Jackson versus City and County of San Francisco. San Francisco. Abrogated on other grounds by Bruin. Thus, we have recognized that laws regulating ammunition fall under the ambit of the Second Amendment. Okay. Therefore, at the first step of Bruin, the text of the Second Amendment applies to the right to keep and bear operable arms, which includes the right to have ammunition, page 23 at the top. We have also recognized that the right to keep and bear arms wouldn't mean much without the ability to acquire arms. Therefore, laws imposing conditions and qualifications on the commercial arms of sale of arms implicate the plain text of the Second Amendment if they meaningfully constrain the right to keep and bear arms. To be sure, the Second Amendment does not elevate convenience and preference over all other considerations. By let's see here, hold on a sec. I'm avoiding like long quotations. Okay, so a minor constraint on the precise locations within a geographical area on where one can acquire firearms does not meaningfully constrain the right to keep and bear arms. Okay, he's quoting precedent. By contrast, the monthly metering of firearms purchases meaningfully constrains the right to purchase and possess arms and thus is presumptively unconstitutional. That's Wen versus Bonta, fresh off the presses on that one. And by the way, that's not going en banc. That is firm precedent now, thanks to the Republicans on the Ninth Circuit. At the second step of Bruin framework, a court must consider whether the challenge rule is consistent with this nation's historical tradition. This is where you want to pay attention. We're in Roman numeral 2, letter B. The determination whether a law comports with historical tradition will often involve reasoning by analogy. When reviewing historical analogs, courts should give particular weight to laws in effect closer in time to the adoption of the Second Amendment, 1791. That's AD, not BC. And the 14th Amendment, 1868. Again, AD, not BC. Courts may consider later laws which can liquidate and settle the meaning of disputed or indeterminate terms and phrases in the Constitution. However, courts should be careful not to give too much weight to post-enactment laws. When determining whether a historical regulation is a proper analog for modern regulation, the courts must consider whether historical and modern regulations are relevantly similar. Sounds good to me. Hold on a sec. Okay. However, courts should be careful not to give too much weight to post-enactment laws. To the extent later history contradicts what the text says, the text controls. Okay. When determining whether a historical regulation is proper analog for a modern regulation, courts must consider whether historical and modern regulations are relevantly similar. This analogical reasoning process is neither a regulatory straitjacket nor a regulatory blank check. The law is not trapped in amber, and the Second Amendment permits more than just those regulations identical to ones that could be found in 1791. How are you guys doing? I'm going to let you see my face for a bit. How are you guys doing? You guys, this is reason to celebrate. Don't get, the people on our side, we get really bummed. I understand. Have a cigar, man. Have a little bit of whiskey. Check in with friends. Check in with family. Which reminds me, I got to call my sister back. She called me in September. We don't normally go this long. I'm probably a bad brother. I'm not like, I feel like I could have been a better brother. I'm the oldest. I think that God holds older people responsible for the younger people, but that's me. That's me, guys. Let's continue. We're reasoning by analogy. Okay, that's what he's saying. That's what she is saying, Ikuda. We're reasoning by analogy. Who is Ikuda? This is bothering. I think it was Bush that appointed her. I'm going to double check here. I'm going to make sure I get this right here. Pretty sure. Ikuda, Ninth Circuit. Let's see. Pretty sure she's a senior judge. George W. Bush. Yeah, I was right. Good for her. Good for her. Yeah, she looks like a liberal. She looks like a Democrat, but good for her, man. This is her right here. This is Wikipedia. I don't necessarily go all the way to Wikipedia. She received a Master in Science degree in journalism from Columbia University. No way. Wow. She worked for Disney Channel magazine. Oh, man. Guys, I would have thought that this one was not on our side. She went to Cal Berkeley for her undergrad, dude. And then journalism at Columbia? Not a good sign. UCLA School of Law. She clerked for Alex Kaczynski. That's a good sign. Not a perfect human being, but he's good on the Second Amendment. And then Sandra Day O'Connor. Okay, well, that's not necessarily a good sign either, but good for her. Good for her. She's a member of the Republican Party and the Federalist Society. Good for her. Wow, praise God. That's great. Oh, man. She had a hard time getting confirmed. And finally, when the Republicans were... Okay, so she has said she's going to take senior status as soon as her successors. So she is really good. Because what she basically said in 2025, she said Trump can replace her. That's what she said. Good for her. Oh, that is such good news. Oh, that is good news. I'm glad I looked at that. I'm really glad I looked at that. Wow. You know, I think I looked at that before. I probably did. I look at a million things. That was really encouraging to me. Okay, so we reason by analogy. Two factors are central to the determination whether a rule is relevantly similar. How and why the regulations burden a law-abiding citizen's right to armed self-defense. For the challenge rule to pass constitutional muster, it must be a well-established and representative historical analog, not a historical twin. So two factors are central to the determination of whether a rule is relevantly similar. How and why the regulations burden a law-abiding citizen's right to armed self-defense. In assessing the why, we look at why the historical analog regulated firearms and whether it was enacted to address certain problem. If a historical law addressed a certain problem, modern laws that impose similar restraints to address a similar problem are likely constitutional. In assessing the how, okay, that was the why. In assessing the how, we consider the nature of the challenged law's restriction of the Second Amendment's right. Even if a firearm regulation has permissible purpose, the why of the regulation, it is unconstitutional if it restricts the Second Amendment right to an extent beyond what was done at the founding or at Reconstruction. By the way, that's Republican Reconstruction. We now consider the constitutionality of California's ammunition background check regime applying Bruin's two-step framework. A. We begin with whether the plain text of the Second Amendment applies to Rohde's proposed course of conduct, acquiring ammunition. California does not dispute that the ammunition background check regime impacts the people that the Second Amendment protects. Okay, as the rule applies to all residents of California. Yeah. Furthermore, because ammunition is necessary to the operation of a firearm, California does not dispute the right to keep ammunition is entitled to protection under the Second Amendment. Okay. Looking at a footnote right now. Okay. Page 26. Laws that impose conditions and qualifications on the commercial sale of arms are presumptively constitutional if they meaningfully constrain the right to keep and bear arms. Because Rhodey asserts a facial challenge in considering whether California's ammunition background check regime meaningfully constrains the right to keep and bear arms, we look only at the text of the challenged rules. As discussed above, a person who wants to keep an operable firearm must necessarily acquire ammunition. Because the right to keep and bear arms includes the right to keep operable arms, rules on ammunition acquisition implicate the plain text of the Second Amendment if they meaningfully constrain the right to keep operable arms. She's quoting there or citing there some of the most rare animals that you can see ever, which is pro Second Amendment precedent at the Ninth Circuit, brand new in 2025. Nguyen versus Bonta. Yeah, it did not go en banc. I mean, the Democrats lost one of their own on that one. An Obama judge came over to our side. We covered on the podcast.
You did?
Yeah, we did. We conclude that California's ammunition background check meaningfully constrains the right to keep operable arms. California ammunition background check regime regulates all ammunition acquisitions by California residents. The regime applies not only to every transaction in California, but also to every ammunition purchase by a California resident outside the state. It requires California residents to pay for and complete an in-person background check before each ammunition acquisition. Though not all the rules comprising California ammunition background check regime impose delays on their face, they do not require California to prove checks within a certain time frame. Requirements prior to various types of background checks, such as fingerprinting, inherently cause some amount of delay. After approval, moreover, a California resident may be required to purchase ammunition during a specified period of time, 18 hours, after passing a background check. The regime applies to all types of ammunition, including .22, and California residents cannot avoid the background check requirement by taking advantage of internet or out-of-state sales. Rather, out-of-state purchases are subject to additional delays and fees. Given the fees and delays associated with California's ammunition background check regime and the wide range of transactions to which it applies, we conclude that in all applications, the regime meaningfully constrains California residents' right to keep and bear arms. Thus, it is not presumptively lawful regulatory measure. Taking a look at some of these footnotes. I mean, I have it printed out and I've got my notes here. I'm not really reading my notes. Maybe I usually I just have a check mark. But I'm not giving you all of my interesting commentary. I think I will go ahead and give you a little bit of my commentary when I read this back in July. Because that's why you... No, I gave that one. You know, the funny thing is I said the same thing I wrote. I don't have to give you that one. Okay, on page 25. Let me go back up to page 25. Here we are. Part of this footnote 15. Defining the proposed course of conduct by reference to the challenge regulatory requirements is inconsistent with Bruin, in which the Supreme Court defined the proposed course of conduct as carrying handguns publicly for self-defense, not as carrying handguns publicly without meeting the requirements. Okay, hold on. California attempts to characterize the proposed course of conduct as purchasing ammunition without complying with any background check requirements. What do I say? Okay, I say, wow, this is a basic problem. Note 15 has a basic problem. No, it's not a problem with what they're saying. It's a problem with the California law. Yeah. So the Democrats, in fighting this challenge, misdescribed what the plaintiffs were up against. They misdescribed it, and that's noted in footnote 15. That's very good. Yeah. They misdescribed the actual activity that is regulated. Democrats misdescribed it in order to try to get a leg up. The Republicans caught it. Yeah, the actual activity is just purchasing ammunition. But they said purchasing ammunition without complying with any background check requirements. That's a misdescription of the activity. Okay, I want to alert you to that. And then page 26, paragraph 2, we conclude that California's ammunition background check meaningfully constrains the right to keep and bear arms. I say amen. That's the very purpose of the law. That's why it exists. That it's dialed in. Page 27, at the very top, I said, wow. Required California to approve checks within a certain time. And then in the footnote 17, I said, contrary to dissent. She says, contrary to dissent, does not require department to approve ammunition purchased within a specified time. Yeah, this is the second factual error of the dissent. So the dissent has been noted to have two factual errors here. Judge Beebe, who's the Mormon guy, who should have the right answer but doesn't. Republican, appointed by Bush, got the wrong answer here. Footnote 18, 24 states filed an amicus brief. I put only 24. And then I put, it's a shame my home state, Colorado, is not one of the states on the list. That's a shame. That's a shame right there. I got a lot of notes on page 28. See, I print it out. And I make notes. I make lots of notes. I'm not just winging it over here, guys. I read everything. I read every word. And I think about it for months, oftentimes months before I have it on the podcast, sometimes years. In several cases, we've done topics which I've thought about for years. Sometimes decades. Decades. This is not a thrown together podcast. That doesn't mean that it's entertaining. I know it's not entertaining. You think I'm doing it to entertain you? Lord, have mercy. You want to see something funny? Let's have some. You want some entertainment? I'll give you a little bit of entertainment. I'll show you the YouTube channel. Just had this kid on. This guy's great. I love this kid. Micah. Just had this kid on. I want you to see some of the comments. We got 5. We have 5 comments. I didn't know we had 5. Why is it only showing 4? You think that we can't handle the 5th comment? What is this? Let me see. Newest first. Okay. Here's the comment I wanted. Could you people be any more boring? Several dots, Jez. J-E-Z. I think he means G's. And I said yes. Because he asked a yes or no question. Could you people be any more boring? And I thought about it, and I was like, yeah. Yeah, I think that's possible. I think. I mean, I don't think it's a request, but I think he was just asking about the possibility of it. And so I said, sure, yeah, we can be more boring. So I think that was funny. I'm not here to entertain you guys. Education is not entertainment. Basic category error there, buddy. Let's see, footnote 19. I think I want to share this note here. The dissent's argument that California's ammunition background check regime does not meaningfully constrain the right to obtain firearms because it imposes a $1 fee and a 1-minute delay in 99% of cases is wrong. First, we consider only the text of the challenge rules in assessing a facial challenge. She's citing Nguyen versus Bonta, 140th volume of the 4th series of the Federal Reporter at 1240. Oh, that's so awesome. We won that. It's one of the rare wins we've had at this Ninth Circuit. An Obama judge came over to our side. I covered it on the podcast. We only consider the text, and the text does not limit permissible delay times. She's bringing the fire there. And then I said, in my notes, I said what it permits rather than what is typical is what she's going after. Yeah. And then I said, wow, BB, you idiot. Would I say that too? Second, the dissent's factual allegations about California background check regime are contrary to the district court's findings that Californians are denied the Second Amendment right to buy ammunition for self-defense at least 11% of the time because of the problems with the background check system. This is where I say, BB, you idiot. Yeah. Your constitutional rights are hinging on whether the department keeps records well, whether these Democrats are doing its job in keeping accurate records. What could go wrong when your constitutional rights depend on another entity hostile to those rights keep records correctly? What could possibly go wrong? Jeez. Where were we? In 3 of our prior cases, B&L Productions, Texera, and Nguyen, we won Nguyen. Nguyen is good precedent. Boom. Are helpful comparators. The other ones were the interest balancing, but they're okay for our side. Nguyen is excellent for our side. In Texera, we held that a zoning ordinance made it virtually impossible to open a new firearms store in unincorporated Alameda County, did not violate the Second Amendment because buyers could freely purchase firearms within the county. 10 existing stores, including one 600 feet from the plaintiff's proposed retail location. Okay, that's okay. It's not great. We reason that gun buyers have no right to have a gun stored in a particular location as long as their access is not meaningfully constrained. Okay, fine. Whatever. I don't like that, but fine. You're talking about zoning. It's a different conversation. In B&L Productions, we likewise concluded, she's talking about Ninth Circuit precedent. This is under the, interest balancing thing that existed before Bruin. B&L Productions, we likewise concluded that a California law banning firearm sales on state property did not implicate the plain text of the Second Amendment, where plaintiffs essentially conceded that the law did not meaningfully constrain the right to keep and bear arms. Okay. Yeah, all right. We explained that restriction on firearm acquisition does not meaningfully constrain the Second Amendment right, where plaintiffs can acquire the same firearms down the street. Okay. We stated that while a ban on all sales of certain type of gun or ammunition in a region generally implicates the Second Amendment, as such, a ban meaningfully constrains the right to keep and bear arms. That firearm and ammunition, a minor constraint on the precise locations within a geographical area where one can obtain firearms, does not. By contrast, now pay attention to this one. Nguyen, that's 2025, good precedent, involves, that's the one that fully incorporated Bruin on our side. We brought an Obama judge onto our side, which is why it didn't go en banc and didn't get overturned. By contrast, Nguyen involved a facial challenge to a California law that prohibited most persons from buying more than one firearm in a 30-day period. We held that this law meaningfully constrained the right to keep and bear arms. We explained that the plain text of the Second Amendment protects the right to possess multiple firearms. We concluded that the government could not temporarily meter this right by barring citizens from purchasing more than one firearm per month. Yeah. California ammunition background check regime is not like the laws challenged in Texera and B&L Productions. That's the crappy precedent. It's okay. It's not. It's okay, but it's not like Nguyen. On their face, the rules changed in Texera and B&L Productions did not meaningfully constrain the plaintiff's right to keep and bear arms. The challenged zoning ordinance in Texera applied to one county, though the challenged law in B&L Productions applied statewide. That was the gun show fight that we had for several years. They affected only the ability to contract for firearm sales on state property, did not affect firearm sales on privately owned property. But California's ammunition background check regime applies on its face to all ammunition transactions entered into by California residents, including transactions that occur in another state. Let that sink. I've highlighted that for you. I want you to tattoo this on your eyelids and study it at night. Seriously, guys. And similar to the one gun a month law, Nguyen, California's ammunition background check regime on its face delays the ability of California residents to bear operable arms by requiring the completion of background checks prior to all ammunition acquisitions. Considering together the cost, delays, and geographic scope of California's ammunition background check regime, we conclude that California's ammunition background check regime meaningfully constrains the right to keep and bear arms. Under the first step of Bruin's analysis, California's ammunition background check regime implicates the plain text of the Second Amendment. Therefore, the government must carry its burden of showing that California's ammunition background check regime is consistent with the nation's historical tradition of firearm regulation. As such, we turn to the second step of the Bruin analysis. And once they've gotten this far on page 31, the rest is the historical tradition analysis, which they're going to lose. They're going to totally lose, because there's nothing in the historical tradition that is a relevantly similar analog to what they're trying to do. And because of that, you'll see on page 31, California proposes 4 different historical analogs: loyalty oath requirements, loyalist disarmament provisions at the founding and during Reconstruction, 19th century concealed carry permitting requirements, surety laws imposed at the founding on page 32 at the top, and on persons who presented a danger to the community, and licensing and record-keeping requirements imposed on vendors of gunpowder and firearms. We consider each in turn. So you got number 1A, and these are just, well, like, okay, here's number 1. California first points to the founding and Reconstruction era loyalty oaths and loyalist disarmament requirements. We conclude these historical regulations do not have the same why and how as California's ammunition background check regime, and therefore are not relevantly similar to California's ammunition background check regime. And she goes through this. I'm just scrolling now. And she says, neither the how nor why of these historical regulations is relevantly similar to California's ammunition background check regime. I mean, I'm on page 34 now. It's page 35. She says again, 34, page 34. Again, these laws are not relevantly similar to the how and why of California's ammunition background check regime. In each historical case, the why was the problem of persons who were not loyal to the state. The restriction on their Second Amendment rights could not be removed by the one-time action of taking a the restriction on their Second Amendment rights could be removed by the one-time action of taking a loyalty oath. Neither the why nor how is analogous to requiring ordinary citizens to undergo a background check every time they wish to purchase ammunition. I was going to say, it's like saying the right to drive a vehicle. Okay, I just got a driver's license in the mail. I had to request, may it please the Crown for me to drive a vehicle in California. I don't have to ask permission every time I drive my vehicle and pay a fee for that. You see a difference there? Hello? 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 I on C, page 35, I say during Reconstruction, well, she says during Reconstruction, a number of states, primarily former Confederate states, those are Democrat states, required individuals to take one-time loyalty oaths before enjoying certain privileges of citizenship. But none of these historical regulations on which California relies expressly conditioned firearm ownership on taking an oath. I say in my comments here, Democrats are using Democrat precedent. You can't make this up. The Democrats are using Democrat precedent from during the Civil War. It's not that surprising if you understand Democrats like I do. The spirit of the Democratic Party is tyranny. The tyranny of the plantation. It's the same spirit, guys. It's the same religious spirit. My cigar went out. I had to relight it. D. In some, California's reliance on these founding era and Reconstruction era regulations is misplaced because their why and how are not relevantly analogous to the how and why of California's ammunition background check regime. Next, California proffers concealed carry restrictions. And the same thing. I'm on page 38. Many of these rules were enacted years after Reconstruction and are so entitled to less weight. Man, she dispensed with that really fast. California next proffers surety laws. You know, I'm scrolling down. I'm on page 39. Important here, surety laws targeted the misuse of weapons. That's not at issue here. And she's bringing the receipts. There's an important quotation on page 39 in that second paragraph. I'm going to highlight it for you. A person, where is it? A person could obtain an exception to use arms for a legitimate purpose, such as for self-defense. There's no such exceptions here. Page 40. In Rahimi, the Supreme Court concluded that surety laws were relevantly similar to 18 U.S. Code Section 922G8. After a court makes a judicial determination that an individual represents a credible threat to the physical safety of an intimate partner or child, it may then issue a restraining order precluding that individual from possessing a firearm for a certain period of time. Okay. Fine. She's distinguishing Rahimi from this, though. She says, though, that even assuming that the why of California ammunition background check to ensure that prohibited persons cannot access operable firearms is relevantly similar to the why of these surety laws, its how is unquestionably different. The how of the surety laws was to impose a judicial process that required a person who was likely to engage in future misbehavior to post a bond for a limited period of time. By contrast, California's ammunition background check regime is imposed on all residents of California without any judicial process establishing that any such resident is likely to disturb the peace in the future, nor is California's ammunition background check regime limited in time. These are not analogs. Historical regulations on vendors of gunpowder and firearms. This is to prevent fires. Totally different. Totally different. We're on page 44. And it's totally different. Time after time. It's all history and analog, argument by analogy. Page 43 at the bottom says, the aim was to prevent accidents such as fires. Okay? And I just said yes, 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 and yes. Page 45 at the bottom. Let's see here. They're not citing laws that are even close to the correct time frame. On page, okay, go to C. On page 49. Oop. Overshot. Page 46, sorry. In other words, the Supreme Court indicated that shall issue regimes may be constitutional, but did not hold that they were per se consistent with the Second Amendment. Okay, that's an important quote. Page 47. California ammunition background check regime is not analogous to a shall issue licensing regime. That's a pretty important point right there. Why? Because of the license. Like I just said with the driver's license. I don't have to ask permission each time I use my vehicle. I have a license for 5 years. Paid $45 for it. It also says I'm a veteran of the United States military, and it confirms I'm a United States citizen. So that I can get in an airplane. So it does other things. It not only allows me to drive, it allows me to get on an airplane. Okay, let me show you a really important quote on page 48. We reject the dissent's contention that an analysis of Bruin's footnote regarding shall issue licensing regimes must precede the application of the Bruin's two-step framework. This approach gets the two-step Bruin framework inquiry backwards. Oh man, that's a big problem. I can't believe a Republican got that wrong. It's sad. This is all good stuff, and I encourage you to read the whole thing. We don't have time for it tonight. This is already going on 2 hours. So we're going to just skip to the bottom. Page 54. And I think we've covered the vast majority of it, but she says, by subjecting Californians to background checks for all ammunition purchases, California's ammunition background check regime infringes on the fundamental right to keep and bear arms. Because California's ammunition background check regime violates the Second Amendment, the district court did not abuse its discretion in granting a permanent injunction. Thanks for joining me on the Republican Professor Podcast. I've been your host, Dr. Lucas J. Mather. I also have a master's degree, and I'd prefer to be called master if you know what I'm talking about. Been enjoying a Toasty Jones Connecticut, which I've had for over a year, and it's still fine. I don't have a humidor, and it seemed to be okay in a plastic bag. In the semi-arid SoCal, I'm in the famous epistemologist's backyard. Dr. Doug Guyvet, a guest on this podcast. Check out his book on the New Apostolic Reformation, co-authored with Holly Pivick. He actually has 5 or 6 or 7, I don't know how many study guides and stuff, books. Check those books out. Check out his books, his writing. Thanks for joining me on the Republican Professor Podcast, and we'll catch you next time. It's 25 October 2025, years after Jesus. We'll see you later. How'd you guys think that went? good. Yeah. Okay, what's next? I found this lighter on a beach in Monterey. Used it to light a fire on the beach, which my wife enjoyed, and I enjoyed it. It's actually Monterey County. It was Pacific Grove, technically, a Silomar.